Hey everybody, how's it going? This is Eric Johnson here. I know it's been a while. Some people said, what's going on? I have a visitor. My sister is living with me while she has her house renovated, and she's getting the entire subflooring redone. She's getting her floors redone, and then she's getting her bathrooms redone. So, because she does not have a bathroom to use, she's living here, and everything's great. We're getting along great. Yeah. So I don't do the videos while she's around, and it's a long story. And so therefore, she's gone at the moment, so I'm able to get the videos in. Hopefully, this will only go on for a couple more. Maybe a week or two at the most. She's already been here like 2 weeks. It's a big job she's having done our house. And I've been over there and helped, like sit around and if they have questions and stuff, well, she does other stuff. But mainly it's been her having to live here, which has been it's been a lot of getting in. Oh, it's been okay, I guess. That's what family's for, right? Okay, here's the deal. So my legal friend, he contacted me. He said, "Hey Eric, are you aware that Erskine has come out with another motion?" So if you saw, I'm putting this in the same playlist with the other two videos about Barb and Erskine. And as we know, Erskine got hit with legal fees for the Zen Estate. The Zen Estate? The Fenn Estate. The Fenn Estate and ZOE'S. The court told Brian Erskine, this is my opinion, this is me reading, this is me paraphrasing, your case was so frivolous and such a waste of time for both parties that you're going to pay the legal fees for the Fenn Estate for ZOE'S. My friend estimated that's probably, somewhere he saw that was like $100,000. And of course, he doesn't know exactly how much Brian Erskine has had to pay his own lawyers, but he figured probably a minimum of at least $25,000. So we figure Brian Erskine's probably in the whole $125,000. So I'm of two minds about what Brian Erskine did. Brian Erskine has come back now, and he has said to the court, I don't think I should have to pay those the Fenn Estate fees. And I asked my friend about that. I said, I don't know. It just seems like he just keeps on, this thing keeps on going. You would think the court would be more aggravating. He said, yeah, true, but also it's kind of expected. I mean, nobody just, I'm probably saying more than he told me, but it's kind of like, you just don't get told something like you're going to pay both fees, both attorney fees, and just accept it. Although, I think I would. That was just his take on it at the moment. I mean, I don't know. I think I would just realize that the court's really not happy with me. And this is what my friend said. The court's not happy with him. To make Brian pay the Fenn Estate attorney fees, they're saying, hey, look, this was, not cool that we had to go through this waste of time. Because the court only learns what is going to be presented as the case goes on. And by the end of it, I think the court pretty much said, Brian Erskine has really wasted our time. So they said, you're going to pay for both attorneys, the plaintiff and the defendant. And Brian, of course, as you would expect, doesn't want to do that. I don't blame him. Okay. So here it is, and we're going to go over this briefly. I will say this about, and my friend also agreed with me on this. I said, when you get the hang of what's being said in court cases, the language is constructed to make it far more complicated than it really needs to be. And he said, well, that's somewhat contrived. He said, there are things where you have to have a lawyer do certain things. Attorneys' training is necessary to do many aspects of legal work. But in some cases, if the language was simpler, if it was made more a language of the average layman, like you and, like me, for instance, a lot of people could probably argue simple cases, and the language alone makes it more complicated than it needs to be. And of course, that helps attorneys because then they get these simple cases where it's just a matter of being able to read the legalese to make the case. So I've always suspected that's true. I'm kind of getting a hang for reading legalese now. It's kind of this truncated language, and sometimes they just put in different words to say what other words are. So this is response to Rule 54 motion for attorney's fees from Brian Erskine. He don't want to pay him. He doesn't want to pay him. There. Everybody have a good day. We have finished this video. Brian Erskine does not want to pay the attorney's fees for ZOE'S, and but we're not going to let it off that easily. The very first paragraph was the one I had to ask my friend. I said, I've been going over this. I have no idea what he's trying to say. The first argument, I guess, is that the order might reflect significantly partial defense merits success. Have you ever heard a more butchered headline? The order might reflect significantly partial defense merits success. I could not understand what that meant, even after reading the paragraph. Despite Forrest's semantic denial only of bilateral contract, the order strongly doubts unilateral contract, the order being what the court said. When my claims enjoy benefit of that doubt at the rule stage and expresses that contact might exist seemingly as affirmed by events immediately after service. I mean, have you ever heard more gobbledygook? Here's the bottom line of what Brian Erskine was saying in the first paragraph, which completely went by my head. He is saying that because the court did not really address... Okay, Brian Erskine felt there was a contract between him and Forrest Fenn. I have mentioned this before. Is there a contract? When we read that book, or books, and Forrest Fenn said, you know, if you follow the clues and you follow the hints, you're going to find that treasure. But you got to follow them right? Did we have a contract? I've talked about this before. Could there be a class action suit? Is it reasonable? And by the way, nobody seems to be interested in having a class action suit that I've talked to in a legal sense. Okay? So I'm just letting you know that. I mean, I'm not instigating one. I'm certainly doing nothing about it. But I can tell you from people I've talked to that no one you might even think would want to do it is interested in doing it. So, the point still stands, though, that people like me and others feel like there was kind of a contract there that, you know, if we followed the clues and the hints, we should be able to find the treasure. And you might say, well, Eric, yeah, okay, but everybody's doing that, so everyone has a shot, and who really knows if you got all the clues and the hints right, so blah, blah, blah. I agree with all that, too. I'm now muddying the waters because I'm bringing in a different aspect of this, my own aspect. I still say, though, as long as we don't know where the damn chest was located, then we'll never know if we were right. And that really bothers me, and it should bother other people too. Forget the class action suit bit. I just think it's really weird that a treasure hunt that went on for 10 years, that 4, 5, 6, even 7 people perhaps died trying to find the chest. I think it's really weird after supposedly tens of thousands, if not 100,000 people searching in the mountains, spending their money, etc., tried to fit the clues and the hints of these books that they bought from Forrest Fenn together to find the treasure. I find it really amazing. We're probably never going to know the location of that treasure chest to even know if we were even close. I mean, it just blows my mind. A 10-year treasure hunt, and no one will ever know, apparently, whether they were even close to the treasure, except that if they were in the state of Wyoming, they were closer than people who weren't in the state of Wyoming. But really, folks, this is amazing. We're not apparently never going to know the location. Some people have said, well, Jack has said I've heard people say, well, Jack has said he's going to sell the location or the solve along with the treasure. I'm not sure if that's true or that's just a rumor. Let's get back to the case, though. The order might reflect significantly partial defense merit success. What Erskine is saying here is that the court never really addressed his concept of the contract bilateral. Fenn apparently denied they had a bilateral contract. You know, Fenn said, look, I didn't have, none of this constitutes a contract between Eric Johnson and me, because Eric was out there looking and felt he had all the clues and the tips and the hints right? And it's not a contract where we both are sharing the same contract, Fenn says. He said that about Brian Erskine. He said, no, we didn't have any bilateral contract going. There's certainly no signed contract to get onto that level. But the concept that if you followed the books, well, Brian's attitude is, no, this is how crazy, and I said it in the last video, it's how crazy Brian Erskine is, in my humble opinion. Just allegedly crazy. Maybe not crazy. I don't know. Dumb? I don't know what Brian, and I'm being sincere about this. I still do not know, and my legal friend feels the same way, what Brian was trying to achieve. Because the concept that you had, because you think you followed the clues and the hints right in these books, allows you to say you should claim part of the treasure or all of it, even though someone else found it. Or because you agree you never found it, but since you followed the clues correctly, you should be able to get part of it. Makes no sense to the average person, right? Brian's argument, first thing he says here is, look, the court never really addresses unilateral contract versus bilateral contract between Fenn. So I think in a way, this was his logic in the first paragraph. Just take it my word for it, because my legal friend told me this. He said, Brian is basically arguing that the court didn't really establish firmly that there wasn't a contract, so therefore they kind of agree with him in a sense. And he's saying, so therefore I shouldn't have to pay as much of the legal fee. This whole thing is about Brian Erskine not wanting to pay the legal fees of the Fenn Estate. Obviously he's going to have to pay his own legal fees, but that $100,000 minimum that the Fenn Estate apparently is charging him, you know, that ain't small peanuts. So I understand his pain. I feel Brian's pain on this one, but I just have to say repeatedly that, you know, it's kind of a stupid case, in my humble opinion. My friends all saying that. Make sure you say that, in your opinion. I know it's in my opinion. I've got the sign up here somewhere. Okay, so let's get that out of the way. The court, because it wasn't strong enough in Brian's opinion about his to making a decision about the contract, I think they just saw that there was no contract, but he apparently thinks they weren't firm enough about it or something. Okay, here's a real simple one that we all should understand. Number 2, the fee claim exceeds or does not reflect the time, labor, difficulty, and skill this case reasonably required. Now that's a headline I can understand, or a paragraph head, subhead, whatever you call it. He is saying the attorney's fees that they're hitting me up with, that they say they have accrued, don't really reflect the amount of time they should have needed, or the amount of legal, you know, the amount of people researching, etc. All those fees are much higher than they really should be. So that's another reason I shouldn't have to pay their fees, is because they kind of padded the bill, is what I guess he's saying in effect. They kind of padded the bill that they're submitting to have Brian Erskine, pay. So he's not happy about that. That's an easy one, number 2. Gratuitous fee, number 3. Gratuitous fee conference threat to sue for malicious litigation. Apparently they had a fee conference. Brian went to the fee conference. This would be he and the attorneys for Fenn, and they're trying to figure out how much they're going to pay, right? He's going to pay. He went to it. He behaved. And during the fee conference, from what I can see is, Brian says, I was surprised when defense counsel, that's Fenn, I was surprised when Fenn's counsel extemporaneously deviated the fee conference, in normal English means brought up another issue in the fee conference, to threaten a new suit for what Arizona law formally calls wrongful institution of civil proceedings. Defense counsel called it something else, but expressly alleged malice. So what Brian is saying here is they actually brought up the fact they could hit me up with a thing where they think my lawsuit was a wrongful proceeding. Well, I kind of agree with that. Now, if this law exists, is that not a fair law? If someone sues you and it's really... I mean, if someone sues you and it's a batshit crazy lawsuit, don't you have the right to come back and say, not only did you waste my time and effort, but I kind of think you were kind of just giving me the business and making me spend my hard-earned money on defense or on legal fees. I'm kind of glad laws like that are out there. I mean, obviously you'd have to be able to prove it, but people shouldn't be going around and getting on a soapbox. I'm getting on a soapbox here. People shouldn't be allowed to come after you and make you spend your hard-earned money on legal fees, right? With some stupid lawsuit. So that's what these people are saying they could do. And he feels that they are well, he says this unsubstantiated threat. I have to slow down to say that word. This unsubstantiated threat. Wow, he said it fast. This unsubstantiated, well, only if I don't say it normally. This unsubstantiated threat was despite ample exhibited evidence of a level of respect for both Forrest and Zoe and my reporting to police long ago in response. So Brian's basically saying, look, I've been a really good guy about this whole thing. I have a lot of respect for Forrest, Fenn, and Zoe, and I'm not doing this maliciously suing them. But they did say, Fenn's defense did say, you know what, we could sue you for, kind of going after us maliciously. And Brian's saying, I don't think that's right that they do that because they're kind of threatening me, and I don't think they should be able to do that. Number 4, the fee conference unquantified conditional offer to sharply reduce fees in exchange for waiving the appeal. Oh my God, I've got to tell you about this. I didn't know this happened. Brian says, number 4, fee conference unquantified conditional offer to sharply reduce fees in exchange for waiving appeal. While such an offer was germane to the fee conference, this conference where they discussed who would pay what, and in this case it would be Brian paying the Fenn Estate, amid other acts of intimidation such as the March 2020 threat letter, I'm not going to get into that, steady defense publicity. Well, I mean, if you're defending Fenn and stuff, yeah, there's a lot of publicity. I'm not sure. I mean, so what? And this is the part I love. And the gun incident with the process server. Now, I read that and I went, the gun incident with the process server? What the hell is he talking about? We're going to move on to part 2, and I will tell you what that was all about. Some of you probably know about it. I didn't know about it. I don't keep up with Fenn as much as some people do, even though I do these videos. I mean, I keep up. I have certain people that send me a lot of stuff, so I kind of keep up, but there's other things going on. But anyway, so I was very interested though when I saw the word gun and the gun incident with the process server. He's kind of bringing this up to say, look, some bad things happened on the other side, so I kind of somehow don't think I should have to pay the fees either. He's kind of like throwing mud at the wall, like, look at these other things that the Fenn Estate did. Like apparently they sent what he calls a threat letter. I'm going to guess that letter was probably the Fenn Estate just saying, cool it. I'm going to guess they're just saying, cool it, or we're going to come back after you legally. But he mentions this thing with the gun incident, so we'll get to that next part 2, just a second.